May it please your lordship.
Yes.
My lord, yeah, I would like to mention one CAB matter, your lordship. Remember, your lordship has directed me to get the GR number.
Yes, yes.
Your lordship, in that case, your lordship, I have been instructed that that case has already been closed before the CGM court. The cognizance has not been taken and charge sheet has been dropped because of the section 188, your lordship. So in that case, this case will become infructuous.
Already dictated.
Yes, your lordship. I'm extremely sorry for that, your lordship, but both party, we were not aware whether the matter was closed or not, your lordship. But I have been informed that matter has been, no cognizance has been taken and charge sheet has been dropped by the magistrate itself.
Okay.
So, your lordship, let this matter be listed again on your lordship 13, and on that day matter may be closed. I apologize for that, your lordship. Since and the record was not before us, your lordship. Actually, the record was from the.
It was necessary.
Yes, sir.
Okay.
13th. Deeply obliged.
Yes.
I will also be considered the margin for the petitioner. I humbly pray to the gentleman of item number 8. This measurement listed after 2 weeks.
You are for?
I'm actually for the respondent.
Your correspondent?
Yes.
Respondent number? Okay, respondent. So respondent. Okay. You are Mr.
Ivan.
Lana counsel for the respondent with the consent of the Lana counsel for the petitioner. Prays for adjournment of the matter for
2 weeks.
2 weeks. The prayer is allowed. List this matter after 2 weeks. Okay.
My lord, may continue interim matter, interim order.
You are for the petition?
I am for the petition matter.
Okay. The interim order, interim is there. The interim order passed earlier shall continue till the next date. Okay.
How will
Yeah, please, my lord. My lord, I beg to mention item number 24 on behalf of the appellant counsel. Here we have taken the consent from the other side. This matter may be kindly listed on 27th of November.
When?
This 27th of November.
You're for the, it is appellant.
Yes, appellant on behalf of Mr. K. Tanada, leading counsel.
Okay. Mr.
S. Chetri.
Chetri. appearing on behalf of Mr. K. Kama, land counsel for the appellant, with the consent of the other side. Praise for listing this matter on
27th of November.
November. The prayer is allowed. Please do it accordingly. Okay.
My Lordship, I
Yes.
beg to mention item number 25, Lordship. 25 and 26 connected matter on behalf of B. Picha, leading counsel. He's out of station, so matter may be listed after 3 weeks, Your Lordship. For the appellant, Your Lordship.
18 and 25, 26,
Yes, Your Lordship.
rising out of the same
Yes, Lordship.
judgment. Okay. You are Mr.
T. Tarin.
Submit that the conducting counsel, Mr. Bindu Picha, is out of station. And pray for adjournment of the matter for
3 weeks, Lordship.
3 weeks. He has also consent from the other side. The prayer is allowed. Please this matter after 3 weeks.
Obliged, Lord.
May I?
Yes.
My Lordship, I beg to mention item number 23. I'm on behalf of this petitioner. My senior counsel is out of session, so kindly this matter may be listed after 2 weeks. The consent from the other party has been taken.
You are Mr.
MUB,
Land counsel for the petitioner. Appearing on behalf of the land counsel, appearing on behalf of Mr. M. Party, land counsel for the petitioner. With the consent of the other side, praise for the listing this matter after
2 weeks.
2 weeks. The prayer is allowed. List this matter after 2 weeks.
Deeply obliged.
May I please, your Lordship? Lordship, I beg to mention item number 19, IPA comment to others versus State of AP. And Your Honor, your Lordship, I also have taken a consent from the PP also.
What is the last order? PCR. PCR was called for. Trial court record. You are Miss?
Ke Basal.
Mr. Senior is conducting senior is out of stations and praise for listing this matter after
3 weeks, your Lordship.
3 weeks. She has a consent from the other side. According to the prayer is allowed, list this matter after 3 weeks. Okay.
Obliged, your Lord.
Your Lordship, I beg to mention item number 17. I'm for the respondent number 1 and 2. I have taken consent from the other parties. This matter after 2 weeks.
Okay. You are Mr.
J. Modi.
Land counsel for the respondent with the consent of the land counsel for the petitioner. Praise for, when do you want, you said,
After 2 weeks.
listing this matter after 2 weeks. The prayer is allowed, list this matter after 2 weeks.
Obliged.
My lord, I would like to mention item number 18 on behalf of leading counsel, Mr. D. Boje, because of medical condition. Matter to be listed after 3 weeks.
So you will inform the counsel for the petitioner.
Yes, Your Honor.
You are Miss
R. Yaku,
Yapu, like,
Yaku, YAKU.
appearing on behalf of Mr. T. Bozi, land counsel for the respondent with the consent of the land counsel for the petitioner. Please for listing this matter after
After 3 weeks, Your Honor.
the prayer is allowed. List this matter after 3 weeks.
Your Lordship, I'm for the petitioner.
You are for the petitioner?
Yes, and Your Lordship, there is an interim order may be continued.
Okay. Mr. You are Mr.
Mr. J. Karbak.
Land counsel for the petitioner is also present. Staff on para. In the interim, sorry, the interim order passed earlier shall continue till the next stage. Okay.
Obliged.
Lordship, I would like to mention item number 15.
Item
15. So the matter has been mistakenly put up today. The matter has been mistakenly put up today. Item
Matter-
number 15.
Yeah. What is your submission here?
No, the item has been mistakenly put up today. The date. So interim may be continued
When?
after 4 weeks.
Hmm?
You know, we have asked for date, the opposition party. So the
When do you want?
after 4 weeks.
After 4 weeks.
Yes,
You are for the petitioner.
I'm for the petitioner.
Is there any
50.
interim?
Yes,
Have you informed the other side?
yes. So no.
Other side is no objection. Okay, this is criminal petition. Okay, your miss,
Punong Borang.
your name is not there,
No, my name is not there.
appearing on behalf of Mr. N. Hondik,
And only.
planning council for the petitioner with the consent of the other side. Praise for adjournment of the matter for 4 weeks. The prayer is allowed. This is matter after 4 weeks. The interim order. Let us see 15.
My lord, I want to mention,
Just a minute.
so,
The interim order is there. There is no interim. Who said there is when the interim order was passed?
I've only been asked to ask for interim order, like the interim to be continued by my counsel, by
No
my senior.
interim. When it was passed?
I'm not sure your. I have to ask my counsel.
There is no interim order. No interim. Okay. This matter after 4 weeks. There is no interim order passed in this case.
Okay, yes, okay. I will have to tell my counsel.
my lord, I want to mention unlisted bail application. So my prayer is that today bail may be heard.
It's the last item.
Yes.
Okay.
Yes, sir. Well, I beg to mention item number 27 and 28, my lord. 27 and 28. In both the case, my lord, I am both a respondent, my lord. With the consent from the appellant, my lord, I praying for listing of matter on 10/12, my lord, 2024.
8,
10/12, my lord. 10/12,
10, 12.
my lord.
Mr. Kishinkar, direct counsel for the appearing on behalf of the respondent with the consent of the direct counsel for the appellant. Praise for listing this matter on
10,
10,
1, yes, 10,
10, 12.
12, my lord.
The prayer is allowed. List this matter accordingly. Okay. 27 and
28, my lord. Both, my lord. This is arising out of same judgment, my lord.
Okay.
High level.
Yes.
I beg to mention item number 22.
Item
22.
22.
Okay, this matter is supposed to list on 19. Today, only listed.
You are for.
I'm for the petitioner.
Let us see the order. 22. The Adjournment Council, you are for the applicant, sorry, petitioner. Petitioner some steps. This matter has been fixed on 11/11/2024. How it has been listed today, wrongly listed today. List this matter. 19. Case prayed for, list this matter on 19. Okay. Yes. Yes.
Of the review order passed by the
It's a revision. What is wrong in it?
Wrong, Your Lordship, my application has been rejected.
So what is wrong in it, rejecting the application?
Your Lordship, wrong, my application for excitement of the respondents as defendants.
Did not find anything against the person whom you are going to impeach. That's why it was rejected. What is wrong in it?
Active involvement in the issue involved in the money suit. It's clearly there is an active involvement of the respondents, instant respondents in the money suit. So they are ought to be joined as defendants in
What kind of involvement? He was not found involved.
the involvement in my page number, Your Lordship, page number 51. This is the involvement. This is the annexed by the plaintiff himself in the money suit. Is annexure number 4. Page number, Your Lordship, 51. Here is involvement.
What is the name of the person whom you wanted to impeach?
This is, Your Lordship, JK. Notice.
What is his involvement? How he is involved in the?
Your Lordship, the fact of the case is that, Your Lordship, there was an NIT. The defendant number 1 in the money suit, he was declared as the substitute bidder in an NIT. So
The defendant number?
defendant number 1 in the money suit.
Okay.
In money suit number 70 of 22. He, after obtaining the work order, he could not execute the work. That's why he engaged another person to serve a subcontractor who would execute the work. Accordingly, Your Lordship, that person is dependent on 2, who has been engaged as a agent or broker for such the subcontractor. Then again, dependent on 2, again, he could not engage, he could not execute the work. So he again searched another person. That is, this is not, he contacted me. And then again, I have contacted another person. In this way, Your Lordship, series of brokers were here. After
For executing one work.
For one work. For 5 brokers were here. Subsequently. After finding the plaintiff in the finally, the plaintiff in the money suit, he accepted to work the execute the work.
He is the 5th one.
He's in the plaintiff in the management, not clearly. So after that, the defendant number one who won the NIT, he asked for the what's called this commission for obtaining the NIT. That commission has been paid by the plaintiff in the management. So that has been deposited in my account. Then next commission has been deposited in my account. So it was my account was used as a lending account for the entire properties.
You are not connected to the NIT,
Not connected with the NIT.
only the person who gave money.
Yes. So that 10 lakhs money has been distributed among all the brokers.
Five.
Yes.
5 or 4?
Yes.
5 or 4?
Seven in number.
So
Including
another
the-
2.
Including the other 2. 5 more brokers were there, including me. So that 10 lakhs has been divided into all the brokers. So I have particularly mentioned how much money has been given. So after paying the money, the NIT has been cancelled. That work has been cancelled, work order has been cancelled due to some technical problems. So after cancellation, the plaintiff, the person who paid the money, he started asking for funding of the money. That's why after notice from the plaintiff, the person who won the work, the NIT, has issued this notice for refunding of the money. In this way, I have been that the respondent was 1 to 4 in the.
You have given to
Yes, I have given all the money.
the person who won NIT only.
Yes.
How the other person is connected with you, connected in the money suit, because you are to be paid by the one who won the NIT only, to whom you have given money. Whether he distributed or not, it is not your concern. How they can be a party? Maybe they can at best be a witness.
But they will, witness will not be liable to fund that.
So the other person is liable to the person who won the NIT, who has distributed the money, not to you. They are not liable to you.
They are not implemented.
How they can be implemented? It is not. They are not connected with you. How they can be implemented? Because you have given money to Mr. A. A has given to A, B, C, D, E, F, whosoever maybe. It's his under his domain only. It's his discretion. They are not connected with you. You are connected with Mr. A only.
I have in this way, I have contacted them
No, why you have contacted?
for
Because Mr. A only is liable to repay you. If he has given to somebody, he will ask again, and then he will repay you from any source. They are not connected to you in your case, because your demand is only with Mr. A. Your grievances is only against Mr. A only, not against us. A might have not even kept money. He must have might have distributed among other. He might have not kept even a single penny with him also. But then he is liable to you, and your case is only against A, not to any other person. How they can be implemented by you? You have not given them. Maybe he will distribute it. He will eat also. He will distribute also.
This money that defendant number 1, that is Mr. A, that
Yes.
he has served a notice.
It's his case. Then he may file money suit against them. Different issue. He can file money suit against them. But they are not connected to you. So in the revision, civil revision, again you have to satisfy that he has exceeded, that the land court has exceeded the jurisdiction vested on him and her. It's not a question of jurisdiction, it appears. He has dismissed the case on merit because you have not satisfied How do we admit?
Sir, my only ground for filing this revision, despite having their active involvement,
Yes.
despite of their active participation from the beginning, from very beginning, continuously. Yes, if they are not implemented as a necessary party, but they may be implemented as a proper party. What ought to be proper party?
How they can be? They are not connected with you. They are not at all connected with you. Because you have given to Mr. A only. It's not your concern, not your business to know whom the A has, where the A has spent the money. The A is liable to you, and you have only case against A, Mr. A only, not against any other person, because they are not connected with. Thereafter, what Mr. A has done with that money is not your concern. May have invested, may have given to somebody. A will say so many things. I have given, taken from you. I have not used it. Somebody has used it. Then will you impede him? You can't. A will say so many things to save from you. You can't impede all of them.
Because this money was taken from me.
Yes.
And it has been distributed amongst all of us.
Taken from you by him only, isn't it? That is why, if you have given money to all of them, then you can impede every one of them. But then A has taken your money. Then the others are not liable. They are liable to A only, if any.
So, in this page number 51, it is clearly mentioned that in the
Miss Jumsi Enterprise.
yes,
Jumsi Enterprise is A.
A.
Okay. So that is why A will file now money suit against this person if he has given. It is his duty. Oh, he's what you call? Yes, it is his business. He may file or he may not file also. You got it. So what do we do?
In this circumstance, I may be able to withdraw that.
It is better because probably the learned trial court has also given detail. Yes, they are not connected.
In Your Lordship, the plaintiff himself, plaintiff and the defendant all dependent during hearing of this IA, they don't have any objection of including those plaintiffs.
No. It will be trouble for you to prove against them because you have not given them. You have given only to A. It will be difficult for you only. That is where he is playing. If he is telling you that I have, he is playing against you. You will not be able to prove against them. So you can only prove against Mr. A only, not against any other person. Okay, Mr. The petitioner wants to withdraw this revision petition. There is allowed revision petition. Is good now. This is on being withdrawn. Okay. Yes.
Item number 27, 28. 27, I am for the appellant. There is passover, adjourned. So my presence may be shown only. Item number 27, 28. 27, I am for the appellant and respondent adjourn it. That's why my name may be mentioned in the order. Item 27.
Okay, 27. No? Okay. Where is this in permit?
Already adjourned. The permit.
No.
He mentioned it.
Okay, then Mr. I. Ahmed, Planning Council for in 27 and 24. Okay. So this is fixed on oblige. Okay. Item,
May I please, my lord?
okay.
My lord, this bail application is filed in connection to the IMU PS case number 86/24 under section 103 subclause 1/3 subclause 5 of BNS. The section 103 is a murder section, my lord, punishment of murder. So, my lord, in the case, accused was arrested on 19/8/24, my lord. So now he is in judicial custody more than 70 days, 80 days, my lord. So, lordship, we come to page number 11, my lord, FIR, my lord. My lord, page number 11 is FIR annexure A series. Page number 13 is type out copy, my lord. May I read without a FIR, my lord. Subject complaint against Sri Terry Kumar, son of so-and-so, Sri Tana Karwa, son of so-and-so, Tana Karung. This is accused present petitioner, my lord, accused petitioner, Tana Karung.
Okay.
And then it is to inform that on 18/8/24 at around 11 p.m. one Srimati Tolum Yaro and his son Sri Tolum Muna came to my residence and informed me that the above mentioned person had brought my
Your
son.
bail was rejected.
Yes, my lord. Bail was filed before the learned power of session judge at UP. So it was rejected on ground that charges are already filed, as informed by the learned public prosecutor.
Okay.
So bail was rejected. My prayer was that lordship, once charge sheet is filed, so investigation has completed. So detention of the accused person is no more required in the case, my lord. And in fact, my lord, here in the case, 5 persons was arrested, my lord. So 2 has already released on bail on ground of juvenile, my lord. The allegation is that, my lord, there was death of the disease in mysterious circumstances. The fact is that, my lord, the disease was due to he was dead because of overdose of the drugs, man. He has consumed drugs, the maximum limit of the maximum, my lord. So he has fallen on the ground, and thereafter this accused person, he was just accompanied with as a friend, my lord, being invited of the victim. He was accompanied with the victim in that evening, my lord, on a fateful night of evening of 18 August 24, my lord. So after falling down, that he was unconscious, and he was brought to one of the resident of one Muhammad Ahmad Ali, who is a field labor of the some of blazers of the Tigdo village, my lord. So incident was just happening nearby railway track Tigdo village, my lord. So he was later on, this accused person was left the place and he went to his elder sister house at Tigdo village, and after taking dinner, and he went to Dimuk. So at around 11:30 p.m. he was arrested on alleging that he was present during the time of incident.
But the death was due to fracture of cervical vertebra.
Yes, my lord, that is because of, my lord, he was falling on the ground suddenly. All of a sudden was falling on the ground, or maybe fracture on that cervical spinal, my lord. And maybe, my lord, he was just trying to get out from the consciousness.
Your bail application was rejected recently only on that
My-
ground.
Yes, my lord. On worship case diary may be called for. It is not
No,
confirmed that, my lord.
The charge sheet has already filed.
My lord,
So-
charge sheet has not confirmed that whether it was
Yes,
filed or
Mr.
not.
Yes, your lordship.
It appears the charge sheet already filed.
Yeah, if charge sheet is filed after
Pending
filing,
to committee.
yes, your after if charge sheet has been filed, later after filing of the charge sheet, they have approached the court or not, because it is the trial court who is in the best position to decide the matter.
Yes.
Why? So because, your lordship, even if charge sheet is filed, as my brother has submitted, that principle that it is not required for investigation, that will apply not in these cases. It will apply other cases where punishment is up to 5 years, 7 years, 10 years, but not for the offenses where punishment is up to life. Here, your lordship, the prime consideration would be the fear trial. For that, whether a witness has to be feel protected for fear, pre and truthful deposition before the court. So that aspect can be decided by the trial court only, your lordship, if the charge sheet is filed. After filing of the charge sheet, if they have approached the court, then no doubt, your lordship, it will this court can, or the superior court can always have a jurisdiction. No, still now, your lordship, this court have a jurisdiction, but if the learned trial court will be in better position to decide whether his further custody is required or not. Now he's under trial prisoner, your lordship, since the charge sheet has been filed.
On the day of hearing, that is 4/11, public prosecutor approved honorable court that I have stated that filing charge sheet, but whether charge sheet has already filed or not, that has not been ascertained, my lord.
You confirm that.
So my lord,
Yes, yes.
LCR may be, case diary may be called for, my lord.
First, your lordship, we have to confirm whether charge sheet is filed or not. Then, your lordship, either TCR or case diary.
Then you obtain instruction.
Yes, your lordship. I will get instruction after sometime only the pass over 14 days. In
We'll do that. If the charge sheet, I will have to quote.
Yes, whether charge I don't.
After some time. Okay. No, sir.
Lordship.
This matter may close lordships. It's because lordship, already the main charge sheet, the main FIR lordship was quashed lordship.
This is the order, your lordship. The main PT case is already been quashed.
FIR first.
Yes, your lordship. This is the order by the coordinate bench, your lordship. The FIR has been quashed, and this criminal petition is in connection with the same FIR only. So if FIR goes, this is become infructuous, your lordship.
That's the lordship, close lordship.
The accused has approached this court, your lordship. Rajendra Kumar Lahoti. And the victim was Sunita Namchung and her father, this is father.
Then counsel for the petition. And Planet space, no planet petition people. It is something that the FIR into the case has already been passed. Hence the matter has become fractious and case for long matter has become fractious. In view of the above, this criminal petition is closed.
Yes, your lordship.
Okay.
Deeply obliged.
This is a matter relating to a pension of the petitioner. Malal, kindly come to page 16 for me.
Okay.
Short annexures I'll brief the Lord for.
Yes.
So this is a later releasing me from the service on supervision.
On supervision, railway, sir. Yes.
Then kindly come to page 17, lecture 2.
Yes.
This is forwarding of my application by the Deputy Director of School Education, Asia. Enclosed find here with an application along with necessary documents in respect of Sri Tapogizing principal attached under this establishment for issue of BCC NOC for superannuation purpose. This is for cover up. Now type copy and you know to read. Kindly see page 19 and lecture 13. Read is a fortune letter. Under CCS pencil rules 1970, so and so principal attached to the BSc office. Pasigat is hereby released from this establishment on 31st 5/2024 after the service on superannuation or attaining the age of 60 years. Now, what has happened? This was not. Then we have requested. Madam, kindly come to page 20, and actually 4 type copies at page 21. Request for issuance of vigilance clearance. Now, look, I am pausing for a moment here. Madam is aware that job scheme was on Earlier this was
Okay.
SIC. Then later on it was transferred to the CBI.
Right.
That then person there too, I was also, the petitioner was also arrested. And thereafter he was suspended. He was suspended and thereafter by this writ petition 5/4/2023, 19/8/2024, I argued this matter and I got him reinstated in the service.
Okay.
That line 4 is there, 540. So then what had happened is, I was reinstated by this order at page 22. Then I was reinstated by this order, and accordingly, at page 23, on 7/5/2024, right? 7/4/2024, I joined my duty. Now, very pertinently, sometimes it becomes a wonder ball for me as well, why the State Vigilance Department is always sweeping over in issuing NOC to the retired government employees in Adjournment. Somehow, somewhere, something is faulted in that Vigilance Department. But what will happen is, after that case, there's two things, there is a departmental inquiry. Because I was personal non grata in that scheme, APSC scheme for appointment of jobs and all. Because I was just a principal of that school and I have no connections. And then thereafter, what has happened? My wife, in fact, has been made as an accused. And I have not been charged that the CBI in the supplementary charge sheet, I am claiming the leave of this court to produce this.
Anyway, at the moment, what we can do is we can
Yes.
notice.
No, I'm making a small prayer.
Yes.
Also there. Now, in the supplementary charge sheet of the CBI, I have not been charged.
Okay.
That meaning thereby, even
Wife is also
wife is
working?
there. That is at page 2 of the supplementary charge sheet. That's not next. That's why I was.
Wife is also working?
No.
Was also working? No.
Not working.
Okay.
Homemade.
Okay.
The new version of the English.
Okay.
Well, what will happen is, now the real question of law comes. Whether the Vigilance Department has a right to sweep over the issue and deny the NOC to the petitioner to get the pension. The answer is no. If a person is not charge sheeted in a particular corruption case or the criminal case, he is not involved in any of the crime. One moment there is a complete investigation, charge sheet is filed, and if a particular citizen is not indicted as the accused in the charge sheet, that means any departmental proceeding against me become authorized. So therefore, we'll kindly observe, issue notice for the movement, and then might not be observed. Pendency of this writ petition shall not be a bar upon the Vigilance Department to issue NOC to the petitioner so as to enable him to claim the pensionary benefit. Otherwise, the law is well settled. 1972, the CCS pension rules, and 3rd February 2022, 3rd February 2022, CCS OM is there. Office memorandum is very clear. And in that Jharkhand case, 2013, that I have quoted in my synopsis, the law is well settled. Pension is not a bounty. It is a hurdle by the government employed by deal of the long tenure of service. And it comes under the definition of Article 300A of the Constitution in the form of profit. So that conjunctively read with Article 14 and 21. Article 21 has in a direction in the can we make an observation? Since the petitioner has been charge sheeted in the CBI case, so and so, thereby it shall not be a bar upon the Vigilance Department to issue NOC so as to enable the petitioner to claim the pension. But the person is retired, old man, will die. This cannot be a treatment that expected by any employee per se asked from the welfare government. And CBI has not been made party,
That is, madam.
nothing is there.
Okay.
The supplementary charges.
My lord, in fact,
it
is not, you have also not stated in your petition.
Yes.
About the charge sheet. Have you stated anything?
Yes, we said. No, we have not made that. Statement is there. Statement is there.
Okay. Okay, yes.
My lord, I have been served with a copy, my lord,
Okay.
but I think we have not been made a party, my lord. In
Yes.
fact, the Secretary of Vigilance would be represented by the State Councils, my lord, the Senior Government Advocate, my lord. Here what happened, my lord, in fact, initially the case was investigated by the SIC.
Okay.
Thereafter, we have given we have handed over the investigation to the Director of CVI.
Okay.
So as of now, we don't know whether the charge sheet has been filed or not. So since they have not made us party, the Secretary of Vigilance would not know whether there is any charge sheet or whether there is any disciplinary proceeding against the accused persons, my lord. And the CCS rules, as my elder brother has said, my lord. Rule 8 is very clear, my lord, upon when the president can deny the pension, my lord. When there is a departmental inquiry and when there is a judicial proceeding pending against a person. So here it seems there is a judicial procedure pending and a disciplinary action. But since he has annexed the charge sheet, my lord, as of now we cannot say, my lord.
No, that's why, my lord.
Let the notice be issued, my lord. And in the meantime, if lordship thinks fit and proper, my lord.
Addition.
I'll find this, my lord.
Otherwise, as respondent number 4, my lord, the SPSIC, and as respondent number 5, the CBI may be.
Charge sheet was filed by whom?
By the CBI. my lord.
CBI.
Yes.
Then probably have.
Probably it is a necessary party, my lord.
No, my lord, why it has not been made in the supplementary charge sheet?
Because of that only, the NOC was not issued probably.
Probably. Therefore, my lord.
No.
No, that is not the reason. Particulars of accused person not charge sheeted. It's
Okay.
Indian supplementary.
Not charge sheeted.
Not charge.
Therefore, my lord, let them come on records, my lord. Let the CBI be the party, my lord. CBI will produce the records.
But his name was there.
He was arrested, my lord.
He was arrested.
The records is-
Arrested and, okay.
Arrested.
Then probably,
He was suspended.
let them clarify that you have not been charge sheeted.
or any disciplinary proceedings pending against him or not. Therefore, my lord.
Lordship, my brother, he knows the laws, but he has a caliber of always making Nietzsche out of it's weird. On the way duty, I should not make any observation on that. Anyway, well, I will find one additional affidavit, allowing me to find this charge sheet. Leave may be granted to find the additional affidavit, bringing the supplementary charge sheet filed by the CBI.
For state, for a state.
What is
For education department.
Okay.
Okay.
vigilance? Secretary vigilance.
For one.
Lordship, we have not been
Two.
given copy, Lordship.
Two.
Oh, you're for one, okay, for two.
Well, also, I will furnish a copy to you. If it is not released.
Mr. Secretary, Nana Council for the petition.
Okay. No, vigilance is different. I have made it very
No, that's what I'm saying. I didn't submit the copy.
Oh, well, there is a confusion with my brother. This copy ought to have been served to my friend, Mrs. Ete.
That makes I'll be the proponent respondent, my lord.
That's why I was thinking.
Not yet, man, not yet.
Yes.
Therefore, my lord,
Normally, this, the SIC and SIT or the CBI, they are not made as a party in the pension case.
Okay.
So that's why.
But then here CBI is,
Since
Seems
we have,
very important.
we have investigated, my lord, and the status of the case would be, produced by the, or the records will be produced by the CBI, my lord. Otherwise, how would we know, how would the vigilance know? What is the status of the case?
Once supplementary charge sheet is filed, then everything is over your own, you have no role at all. Anyway, I'll see.
petitioner in fact can withdraw this petition and file a press one where everything would be incorporated also.
Once for all.
Once and for all,
Wait,
yeah.
it's okay, it's okay.
Because
This one fellow is disturbing.
starting is something
Let-
else,
let
but
me-
then proper
The
petition is
petitioner
better.
is a
Actually, because the vigilance also has not
retired
much of role.
principal attached to DDAC office, Pasighat, Education Department, Education of Arunachal on 31/5/2024. By filing this writ petition, the petitioner is seeking direction to the Vigilance Department for issuing vigilance clearance so as to enable him to enable the Department of Secondary Education, Government of Arunachal Pradesh, Kanagar, to process the pension paper of the petitioner. Okay, no, you just it is submitted. Leave that. It is submitted that although he has retired, the Vigilance Department has not yet issued vigilance clearance to enable the Department of Secondary Education, Government of Arunachal Pradesh, Kanagar, to process the pension paper of the petitioner, which according to the petitioner is violative of law laid down, violative of law, laid down by the Honorable Appellate Court in the case of State of Jharkhand and others versus Jitendra Kumar Srivastava and others reported in 2013-12 SCC 2010 staff. By filing this writ petition, the petitioner is seeking direction upon the Secretary Vigilance, Government of Arunachal Pradesh, to issue vigilance clearance certificate to process the pension paper of the petitioner staff. That issue notice returnable by 4 weeks. 3 weeks. Okay. Since you are Mr. One is Education Department. 3.
One also, Secretary Education. 1 and 3.
1 and 3. Mr. Appear on behalf of Mr. Sabatabun,
The standing counsel for.
Standing Counsel for the Education Department. Miss, okay. Appear and accept it, have accept the notice.
He will accept notice on behalf of.
Yeah, on behalf of, accept the
Sitaba.
notice on behalf of Mr. Sabatabun, Standing Counsel. Miss Appear for the respondent number 2. Okay, so then, no notice was given to you.
CBI and that SIC and CBI are not paying part.
Okay.
Because the record will be before vigilance only.
Okay. Right. So, further copy is necessary to serve to them? No. Not
The
necessary,
copies
not
I have
necessary.
furnished them, my lord.
Yep, you have received.
No, Lordship.
Okay. Appear. Okay, no. Then, the petitioner shall furnish a copy of the petition to the learned counsel appearing on behalf of the respondent during the course of the days. During the course of the days.
Okay. Yeah, then-
Okay, this is
Yeah.
important. There is no interim period.
No interim
Also.
period.
Okay,
My
then
lord
it's
can-
fine only.
Lordship,
my lord
CBI,
can always-
CBI is a necessary party here.
No, no.
Lordship, let them
So,
complete
okay,
it first,
no,
then
okay,
only
no.
notice may be issued, Lordship. This is not complete, Lordship.
Hmm.
My lord, we have not sought NOC from the CBI.
Still then, Lordship. The investigation part is being done by the CBI
My
without,
lord, it's not like this. It's like vigilance. Department of Vigilance will call for the records from investigating agency if at all required. Normally, this is the procedure. So therefore, my lord, their improvement is not required. My lord, but then my lord will make an observation. If required be, the counsel for the petitioner shall make an endeavor to complete the CBI.
So,
My humble understanding, my lord, CBI is a necessary
necessary
party.
party.
yes.
Why? Because, my lord, whether the charge sheet has been filed has to be forwarded by the CBI, my lord. They said
So, you know, internal department functioning, you know, suppose if an officer is being tried or the vigilance department wants certain clarification, the vigilance department will write to the SIC whether the status of this case from them. They will say that then there's, you know,
I think if from the clarification to be by the vigilance department.
my lord, here, my lord. If the vigilance say we have rejected his application, the representation for certain reasons, my lord. Now, again, we have to call for the records from the CBI. If the CBI is made a party directly, my lord, that process would not be there. It will be easier for him to get the pension. There's nothing, get it easier, my lord. Because the standing council, CBI or the central government council will directly produce the records before this honorable court, my lord. Otherwise, the vigilance would give a reason. Again, the case will be listed. Again, we'll call for records from the CBI. So why not directly make the CBI a party?
my lord, can be so much to impeach CBI. My lord has the power to impeach CBI.
Yes, that can be done.
My lord, we accept that.
It appears that the vigilance clearance certificate was not issued to the petitioner due to the pendency of the case against the accused in connection with. Do we have any number?
Yes, they have given the case number. Last page, my lord. Page 25.
Yes, in connection with.
PCA case number 24 of 22. CBI PS case number 09A.
Okay, PCA case number 24, stroke 2022. CBI PS case number 09. Within bracket capital A, stroke 2022. Within bracket CBI versus Saket Jeram and others, bracket close. So, in view of the above, it appears that the CBI is necessary. The petitioner is allowed to increase the CBI. Implease the CBI as respondent number 4 and serve a copy to the copy will be served today only.
I will serve to me.
Okay, serve the copy to the planning council for the CBI. Okay. So after you file for impediment, then only the CBI will be impeded.
No, no, that's court can directly. Well, that.
Okay, then the registry shall. Registry shall impede. Then in that case, you have to change this.
No, just, they will, I'll, just.
Insertion is not allowed now.
No, I'll just
Amend the course title.
Course title.
Okay, the petitioner shall amend the course title by implementing the CBI as respondent number 4.
Right.
The registry shall do the needs stuff. Okay, list this matter after 3 weeks.
Okay.
Okay.
Yes.
Objection.
Other one, 8 was important. That's correct.
May I please, Mala?
Yes.
Mala, this writ petition is challenging for suspension order dated 19/11/2009, my lord. The fact of the case is, my lord, suspension order dated 19/11/2009, my lord. 2009, my lord. It's
You were
15 years.
suspended in the year 2009.
Yes, my lord. Since last 15 years, this petitioner was on suspension, different suspensions. The fact of the
It
case,
was extended from time to time.
yes, my lord.
Okay.
The fact of the case is that, my lord, just brief fact of the case, my lord. The petitioner was observed in the job as a constable in Arunachal Pradesh Civil Police since 1994, my lord. So thereafter, he was serving for 4 years. So 2009, my lord, he was transferred to security cell PHQ Itanagar, my lord, from Dapur region. So on the same year, my lord, on 28th October 2009, my lord, one namely Tatak Nilan, he has launched FIR.
Yes, there is allegation against you.
Yes, my lord. So thereafter, subsequently, my lord, case was registered at Itanagar PS case. Itanagar
Registered
PS
also.
It was registered at PS case number 178/2009, my lord. Under section 363/376, subclause 2, clause F, and 34 IPC, my lord. So thereafter, I was at the case, my lord, in connection with that case, and I was suspended from 19/11/2009. My lord, the suspension order is, my lord, page number 18, my lord. Annexure B, my lord. I have annexed.
Yes.
May I read out, my lord, suspension order?
Yes.
Where a disciplinary proceeding against of Constable Nectar of Security Cell PHQ Itanagar contemplated for his involvement in Itanagar PS case number so and so under so is under investigation. Now, therefore, the undersigned in exercise of his power conferred by subsection sub-rule 1C of Rule 20 of Arunachal Pradesh Police Discipline and Appeal Rules 1999. Therefore, place the said Constable Nectar under suspension.
Thereafter, it was extended.
My lord, no such kind of extension. Inquiry is conducted against me, my lord.
He was arrested.
Yes, he was
How long
arrested.
he was there inside?
He was more than 2 months, my lord.
What about the case?
My lord.
What about the case? Criminal
Case is, my lord, charge sheeted against the petitioner.
Trial started.
Before honorable trial is proceeding before honorable session court at the UPA, my lord, and evidence are already taken. Only IO of the case is remaining. Victim has already examined and cross-examined. Victim has never been saying that it was attempt to rape by the accused person, my lord. And thereafter, my lord, complainant has also examined by the inquiry officer. He has also cleared the inquiry officer that later on he came to know that there was no such rape attempt was committed by this present petitioner, my lord. And my lord, the inquiry officer also not taken record statement of the victim, my lord, one Chime Nilan. Her statement was never recorded by inquiry officer, which was constituted of inquiry against me, my lord. So thereafter, my inquiry report was submitted, and I was directed to file representation on that is 7 July 2017, my lord. That is page number 20, my lord. I was furnished a copy of that inquiry report, my lord. So accordingly, my lord, based on this letter, I have filed appeal, my lord. I have filed representation before the concerned authority for consideration of their inquiry. Is in inquiry, my lord, victim statement was never even recorded. So I was filed representation on 25/7/2017, my lord. It is page number 39, my lord. So that was not been considered. Inquiry was never been reconducted, my lord. So till that, my lord, I am suspension on 15 years, my lord.
What I'm asking is,
Yes, my lord.
taking from you, the information is that whether the suspension was never been extended
Yep.
by any other subsequent order. Okay. Yes.
Lordship, at this stage, notice may be issued regarding will file our affidavit.
Mr. Rama and Rama, Learning Council for the petitioner. Issue notice, just wait, but filing this writ petition. The petitioner has challenged the impugned suspension order dated 19/11/2009. And also, your prayer for regularization of 7 pay also.
Yes, my lord.
That
7 pay commission, my lord. Since I am on suspension from 2009, my lord. So I am
And
only
also-
receiving
and also-
substances allowances, my lord.
regularization of 7 pay commission of the petitioner from the date of suspension to till date. So, issue notice returnable by 4 weeks. Miss Harmony accepted notice on behalf of your correspondent number.
Or one to all the respondents.
Okay, so the state respondent, then the government advocate accepted notice on behalf of the state respondents. Since Ms. So appeared and accepted notice on behalf of all the respondents, no formal notice need be issued to the state respondents. However, Mr. Rama, the petitioner shall furnish requisite extra copy.
Yes.
To the land council for the state. List this matter after 4 weeks. Okay.
Highly appreciate.
Yes.
Wait, please, Your Lordship.
Yes.
Your Lordship, this writ petition is filed for cancellation of 46 FPS fair price of license that was issued illegally and arbitrarily. I'm a villager. I'm a villager, Bayum village in Siang district. And dear Your Lordship, because of the geographical isolation of the area, in 2015, I ran a FPS there, and the villagers were getting their essential commodities in the price fixed by the department. Now, Your Lordship, what happened is after in 2015, if I may, Your Lordship, take you to page number 25, that is Annexure 2A, and 26 is the type copy, Your Lordship. In 2016, Your Lordship, the 34 number of FPS license were cancelled by the Deputy Commissioner, Siang District. On the ground that,
Fine.
yes, page number 26 is the type copy.
Okay.
It's order passed by the Deputy Commissioner, Siang District.
This order was issued by,
the then Deputy Commissioner of Siang District. And now your lordship may see page number 41.
by this, what the DC want to convey?
Here,
this
your
order?
lordship, that the 34 FPS issued during the year 2015 was against the guidelines. Your lordship, the guidelines is in page number 42.
Guideline prescribe only 2
Yes,
FPS
yes.
annually.
Yes, lordship. Annually 2 FPS in a district.
This was in the
2015.
only.
Yes, the license were issued in 2015 and it was cancelled in 2016.
Okay. So by this order, the deputy commissioner has cancelled altogether 34
Yes, yes, your
number of PFS license.
FPS license, yes.
Okay. Then
And then your lordship, if you see your lordship page number 41, that is annexure pipe. It is the your lordship, the FPS during the year 2015 to 30 had to be issued according to the district wise quota.
page
41, your lordship, annexure 5A. So if you see my
30. What
yes,
is?
2015 to 2030.
How many?
And serial number 21, my concern is Siang district. A total number of 25 FPS had to be issued.
Till 30.
Yes.
So now we are in 24. Siang, 21 is Siang.
Yes, serial number 21 is Siang district. A total number of 25 had to be issued from the year 2015 till 2030.
Now 15, 16, 2. And then now 24, 23, 24. It should be a 2.
2, yes.
Again.
Yes.
So total by now it will be
21.
around 20.
Yes, but your lordship, if you see page number 38, that is annexure 5. This is the list of APS that was issued during the year. Page 38, annexure 5.
Yes, sir.
5.
Page 28.
Yeah, 38.
What is that?
This is the list of license, APS license that was issued during the year 2016 till 2022. Here, the department has clearly violated, your lordship, the revised guidelines by issuing in the year 2017. The department issued 12 FPS license, and in 2018, 22, and in 2019, 11 FPS, and then 2021. Your lordship, it already exceeds the required district-wise quota, your lordship. That is 25 FPS till 2030.
This is total number of FPS license holder dates and so. This is of Siang.
Yes, Siang district.
2016 to 22. Total 15. How many?
Total 46 have been issued.
Okay. Continue.
Yes.
So total till now, Siang district. Who issued this? Deputy Commissioner.
Yes, the license
So
is
issued now 46.
Yes.
Till now it is. Now,
Now, your lordship, this is why I'm agree because there has been there has been numerous number of appeals, but still, your lordship, my village has been, I have been aggrieved, my villagers have been aggrieved because we are not getting the essential commodities, your lordship. That is to be provided
you
by the.
want more.
No, your lordship. That's why I want cancellation of all the APS and then.
Then you will not get even even a grade.
But your
not get-
lordship, if
In spite of establishment or issuance of 46, you are not getting now.
yes,
You want more? No. You
if
want to cancel this? rather.
yes, and then your lordship, it has to be again, your lordship, license has to be issued accordingly, your lordship, to the revised guidelines, your lordship. Now, your lordship, the license has been issued arbitrarily, your lordship.
How many of you are there?
Only one, your lordship.
Only one.
Yes.
Only you are aggrieved.
Yes, my village is aggrieved. I am concerned only about my village.
Have you filed this complaint before the competent authority? in
Yes,
the
your
district?
lordship. Yes, but the competent authority is ready to issue license, but because of the order, your lordship, uh, that is in page number
Where
4.
is your
Also,
complaint? Where is your complaint? Raising of grievances against issuance of
your lordship, in 2000s, annexure 3, page number 29. The type copy is page number 31.
this is for applying for restoration of
Yes, restoration or issue of.
PFS license. What was the response to this?
The response was in your lordship, page number 35, annexure 4.
You are Mr. Sarak Garu.
Sadak Garu, yes.
It was filed on 2017.
Yes.
So this is basically raising that what is the basic contention you raised before the authority, deputy commissioner?
So your lordship, that my license that was cancelled in the year 2015.
You were also given license.
Yes, in 2000.
That was also cancelled.
Yes, your lordship.
When?
2016, same order, your lordship. I was also a PS license holder in the year 2015.
Okay. Now you have not been granted a license again.
Yes.
Instead, the deputy commissioner has granted to some other person.
No, but in my area, the deputy commissioner has not issued any license. So that's my concern.
Okay. You want the license be issued to you?
Yes. But
But again, you have a complaint against the excessive issuance of license.
your lordship, I have been made to wait because I was of the opinion that the license will be issued according to the guidelines. But when I approached your lordship, the concerned department, the department has provided
Now,
us.
what is your grievance? You want the excess issuance of license be cancelled, or you want you also to be issued a license?
Yeah, I want an license to be
So
issued.
it will become 47 now.
Yes.
The
But
same-
that's why, your lordship, my prayer in this writ petition is that the 46 license should be cancelled. That was arbitrarily issued, and then
Then you are
reissuance of
not
license.
entitled, then you are also not entitled then. You
Yes.
cannot claim.
You- Yes, your lordship. Here, lordship, my intention is not that the license should be issued to me. License have to be issued in my area where the villages are being agreed.
No, already there the 40, according to you.
Yes, 46.
Already 46 license has been issued.
Yes.
This, according to you, is in excess
Yes.
of excess issuance of license
Yes.
against 2 every year.
Yes, your lordship.
So now you want that some more license be issued.
No, but this 46 license.
One
will be
license
cancelled.
be issued against your area. And that
Yes.
is also to you,
No, not me, in my area, Your Lordship.
in your area.
Yes.
So you have no grievances against excessive
No.
issuance of license.
If there was in an FPS
You
in
are
my,
giving alternate.
yes,
Either you stop the excessive or you issue them to me also.
to issue, Your Lordship, is the FPS is already exceeded, Your Lordship. So to issue a new license, Your Lordship, that has to be cancelled, according to the guidelines, Your Lordship.
Yes, it appears that every year
Yes,
the license
Lordship.
used to be issued only two. It appears that the authority have issued two license.
Yes,
But he
Lordship.
also want that he should also be issued license.
Because in his area, there is no FPS. That's what his
Yes.
claim is,
Mm.
Lordship. As per notification, Lordship, is clear that in serial 3, in annually, only two has
Only
to
two.
be issued.
Mm.
And since it can be seen clearly that they have issued beyond excess, Lordship.
Mm.
That is not only for, not triple also, more than that, Lordship. So in this case, Lordship, this is notice may be issued
You have to
and
clarify first.
his
Mm.
claim may be, Lordship, just Lordship, that may be observation may be given about his claim, Lordship.
You have to
Because
clarify first.
his grievance is that there is no fair price of in his village.
Yes.
That can be considered by the, if it is true, that can be considered by the Lordship authority, concerned authority, Lordship. And regarding the access, Lordship, this one issuance of FPS license, Lordship, notice may be issued.
Let us see your prayer. What is your prayer?
Prayer at page 19, Lordship.
What is this impugn order 25/9? Have you?
That is, yes.
Hmm?
Page number 35. Your Lordship, because of the excessive increase in the FPS, Your Lordship, the department has kept in abeyance, and Your Lordship, that no new license shall be issued, Your Lordship.
No, you have to clarify what you want.
It's a little bit confusing, but
Yeah, that is right. Because
but
he want more also, he want less also.
he want
He want to control the
in his
excessive, but
place,
he
Lordship,
want also.
in his village.
Hmm.
But then since it is already issued in excessive, the Secretary Civil Aviation has kept in abeyance his application, Lordship. That is the, Lordship. His prayer here. Otherwise, in the prayer, only the cancellation of the
This
46 is.
Order
clear.
25/9, this is annexure.
Annexure 4, page number 35.
Yes, in the second paragraph. Because it is already in excess, Lordship. The new applications has been kept in abeyance, Lordship.
If you are challenging this order,
Yes.
then you see, you cannot claim that it should be maintain the limit. If you're challenging this order, then that means then again you cannot challenge the issuance of excessive license again, because by this order, including your village also, because of the issuance of the excessive license, it will, then it is, the order has been passed, not issue till further order. Now, if you are claiming, then you cannot challenge for against the excessive issuance of the license.
Here, your lordship.
Because you have to, that is why I'm saying, you have to clarify your grievance first.
Yes. If I may, your lordship, if your lordship, this 46 APS license is cancelled, your lordship, and reissued according to the your lordship, the guidelines, your lordship, you're definitely there, your lordship.
Like guideline, you are also not entitled again. Have you clarified that where it is excessive issuance, where it is not issued? Where, in which village,
yes,
there has been an excessive issuance of PR shop, and which village it is not been issued? Have you clarified?
Your lordship, no, that your lordship.
Now you have to clarify that which is to be cancelled, where it is according to you is excess.
Yes, sir.
And then according to the proportion, and then you are entitled, this should be issued after cancelling. To clarify, then totally one way you are saying that it has to be controlled, and again one way you are also claiming that you should be issued. We do not know by issuing yours will control or not, but you have to clarify.
Your lordship, here, your lordship, if I may, your lordship, I'm not claiming the license, your lordship. That
You are not claiming.
No, I'm not claiming, your lordship. My
Yeah.
prayer is just for cancellation of 46 APS that was issued against the guidelines, your lordship.
Now you see, so then you have challenged this order where it says that until further order it will,
Yes,
it will not be issued.
even if your
But
lordship,
it is open, if it is set aside, then they will again issue more license.
this,
It will be open for the authority to issue more and more license.
yes, yes, lordship. I humbly would like to your lordship submit that your lordship, if your lordship, this order is this court is of the opinion that this 46 license is to be cancelled, but then your lordship again to issue a new license, your lordship, this order has to be set aside. That's why your lordship, I have, in my prayer I have mentioned this that this order may be quashed.
It's a contradictory only.
Yes.
Cancellation this court. Lordship.
Because by this order, he's claiming, he's challenging against this order, whereby it says that no further issuance of order,
Yes,
issuance
yes,
of license.
yes.
He challenged this.
Yes.
And at the same time, he wanted that we can cancelled.
Yes, regarding this cancellation for
Then-
cancellation, lordship notice may be issued.
That can be, but then again, this then
That only observation may be given, lordship, that the petitioner claim is
if
that.
if it goes, mean the authority will issue
No,
more.
no, of course, lordship, that authority will see if notice is issued. They will see. It's not that if the court issue notice,
That
then
you have to
it will
clarify.
be all will be
In the
cancelled
later
directly.
stage
lordship.
also, before next hearing, probably you have to clarify your stand.
Yes, definitely.
Now you are pressing for cancellation.
Yes, yes, your lordship.
So if you are pressing for cancellation of the excessive issuance, then you cannot press for the cancellation of the order passed by the deputy commissioner for restricting the issuance of the further order. Is it not?
Yes, lordship.
Two things at the same time, he cannot claim. Okay. Mr.
Kim Ubang.
Lana Counsel for the petitioner.
Lordship, I am for the state respondent, others are private respondents.
The petitioner. The excessive issuance of fair price of license which was issued, which was purportedly issued in violation of the revised guideline by notification number DFCS/MON-11 within bracket notification bracket close stroke 2015 dash 16, dated 3/10/2015. It was 2015. Issued
Yes.
by the Secretary Food and Civil Supplies, Government of Arunachal Pradesh.
But the notification is in page 42. We have an extra notification. 42.
Okay.
And the concerned part is at serial number 3, page 42.
Okay. And praise for cancellation of 46 number of fair price of FTS license illegally issued. Total 46. is
Yes,
it?
yes, Your Lordship.
Okay, by the respondent number, Deputy Commissioner, by the respondent authority. In the prayer, your issuance of license against your village is not mentioned, not prayed, isn't it?
Yes, Your Lordship.
Okay. Then issue notice, no? Para. Issue notice, returnable by 4 weeks. This is the GLD. Direct government advocate accepted notice on behalf of
1 to 5. Was it?
all
That
the
respondent.
sorry, respondent number 1 to 5.
4, Your Lordship.
No, 4, sorry, 1 to 4. No.
Yes, Lordship, 1 to 4.
Okay, since Ms. G accepted notice on behalf of respondent number 1 to 4, comma, no formal notice need be issued to the said respondent staff. However, the petitioner shall furnish decrease of extra copy to the Rana Council for the state respondent during the course of the case. Para. The petitioner shall take steps upon the respondent, the private respondent number 5 to 50
Yes.
within a week from today, by a registered post with AD within a week from today. Stop. List this matter after 4 weeks. Okay.
Extra petition.
Deeply obliged, Your Lordship.
Obliged.
Your Lordship, charge sheet is already been filed, and we have missed out in the order also, Your Lordship. Your Lordship will pass over one.
Sorry.
Your Lordship will find in.
Charge sheet already filed.
Yes, Your Lordship, and Your Lordship will find in page number 21 also. Your Lordship may kindly come to page number 21.
21.
Yes, Your Lordship. The recent rejection order.
Hmm.
Para 5, Your Lordship. I have
Yes.
carefully perused the record and seen the death of deceased was due to fracture of cervical vertebrae associated with injury on spine cord, and the mobile of deceased was recovered at the residence of one of the accused person. It is also observed that the accused person has consumed contraband substance with the deceased before his death. It is observed that a charge sheet is already been submitted. Here also it mentioned. By IO, let the case be considered by learned magistrate for committal, if any. It is observed this is not a fit case for the releasing of the accused at this stage of investigation.
This stage of investigation again.
Charge sheet, it was, has it been committed, already committed or not? yet
Committed, Your Lordship, we don't know, but Your Lordship,
But
I have
charge sheet
taken,
committed.
taken instruction from the IO. It was charge sheeted on 3/10/2024, Your Lordship.
3/8.
10.
310.
Yes, your lordship. October.
So this bail application was also filed only after filing of the charge sheet only.
Yes, your lordship.
411. So then you see on the same ground your bail application was rejected. How do we reappreciate?
My
On
lord,
the same ground,
my lord,
because it was
since
on perusal of the charge sheet only.
my lord, accused has never been involved in the instant
No,
case.
you see the observation. Must have seen the charge sheet. See the
My lord,
observation?
so, in that case-
Disease was due. Date of the disease was due to fracture of cervical vertebrae.
My lord, in that case, charge sheet may be called for, my lord. LCR may be called for. My lord, my lord, we have to observe the, my lord, circumstances whether accused was involved in the case or not, my lord. So, Honorable Session Court is not going through the
Now
fact of
the mobile phone was also
recovered from other accused, my lord,
It's
not from my.
not you.
No, yes, my lord. So, my lord, like, we have to peruse the, my lord,
Now call
fact
for
of the
the,
case.
call for the scan copy. Mr.
Yes, scan copy of TCR.
Yes, ma'am.
Mr. N. Rama, Learning Counsel for the petitioner. So this is an application filed on section 483 of BNSS 2023 for granting of bail to the accused Tanak Karo, who has been arrested in connection with the WPS case.
WPS, my lord.
Here again,
WPS.
they have to obtain GR case number also.
Why you have written WPS?
My lord, I never written. It's the WPS.
PS case. WPS. Correct, huh?
Yes, ma'am.
PS case.
Yes,
Number
ma'am.
86,
The W is
2024, under section 103, within bracket 1, drop 3, within bracket 5, BNS 2023.
GR number is not there.
44, the scanned copy of the trial protocol.
Your lordship, here also difficulty, GR number is not there. Other,
Then it will be difficult to go.
yes, this is the problem, your lordship.
FIR, my lord, in FIR GR number is not mentioned.
It is not with the police because the charge is already filed.
Yes.
No longer with the police.
They can collect
GR
it from
number-
the trial court, your lordship.
You can collect the number.
GR number, because it's
My lord,
committed of-
FIR in GR number is not mentioned, my lord. That's why we could not able
No,
to
that
mention
is
GR
why
number.
it will be with the Chief Judicial Magistrate Court.
Only we have
In the Chief
obtained
Judicial Magistrate
FIR
Court,
and
let's
arrest
find
warrant.
out the number so that we can call the correct
Yes, your lordship.
case. Otherwise, you say how to whom to direct, what number, what case.
My lord, in that case, matter may be again possible, my lord, for timing. Have to collect GR number from GR branch.
Okay. For
In
the
FIR, we have
trial
only
court
collect-
record of the GR number this, huh? That
Yes.
you just give.
Yes.
Okay. From the court now, which court will it will be?
Learned Court of CGM UPI. my lord.
CGM UPI?
Yes, ma'am.
Okay, from the CGM UPI. Mr. P. okay? Appeared. The Learned Edison PP appeared on behalf of the state respondent. At least this matter.
Let it be on your lordship 20.
20.
Yes, your lordship.
20. Okay. Give the number.
Yes.
I don't- It will be difficult, huh?
Much.
Obliged, your lordship.
Lordship. Yes.
I beg to mention item number 7, Lordship.
7. What do you want?
Lordship, debunking unexpected fever. Due to unexpected fever, debunking has left from the court. So kindly list this.
You are for respondent?
Yes, Lordship.
Who is for the petitioner? You have no objection. Okay, is there any interim? Okay. Is prayed for by both the Lana Council for the parties. List this matter again next week. Next week?
Lordship.
Okay, next week. Okay. Item 7.
Obliged.
Yes.
Item number 9, 10, and 11.
9, 10, 11.
Fixed matter this, that may also be adjourned because item number 19 is a connected matter.
9.
9, 10, 9 is connected matter with 10 and 11.
Okay.
So matter will be adjourned together. And after 2 weeks.
After?
After 2 weeks.
Mr. D. Topak, planning counsel for the petitioner. Have you informed the other side?
Yes.
I'm the other side. And the private respondent
Private
also there.
respondents are also there.
No private respondent in the case.
Hmm? In item 9, private respondents are also there.
Yes, also.
9, 10 also. Have you informed?
Not informed.
No, you see, if they are present, then what do we do?
Because other party.
You are for the respondent. You have any objection?
No,
No
objection.
objection.
After 2 weeks.
Okay. Tapak planning counsel for the petitioner prays for listing this matter after 2 weeks, to which the planning counsel for the respondents have no objection. Prayer allowed, list this matter after 2 weeks.
Yes.
Okay.
Obliged.
So rest, we'll take up at 2. Any urgency? Okay. Hmm? Okay.
So far, they have not filed any.
You are for respondent.
Yes.
Affidavit is required, not yet filed since 24. No one is appearing also today. Yes. So what do we do now?
Planning of title or pseudonym or clan, like 2 filters. Petitioner is my younger brother. I am as a elder brother of same family. So there is a dispute that clan Rishi and then one Rishi clan and Giri clan. I claim to be the Rishi clan since my grandfather was a Rishi clan. So after I born, thereafter my grandfather died. As my grandfather was adopted by the husband of my grandmother, second marriage. So thereafter, when my grandfather was minor, so he was adopted and thereafter given pseudonym as a DB family. So according to my grandfather, so my name and my children name also written as a DB family. There is a two pseudonym, DC. In fact, my great grandfather was DC family. So that dispute I have affidavit before executive magistrate court page number 45. My affidavit. I have declared myself a DC family since my great grandfather was a DC family. So thereafter my younger brothers made complaint before executive magistrate ESC NC magistrate. So based on his complaint, the KEVA was conducted. KEVA was conducted and KEVA decision was given in my favor. KEVA decision is by page number start from page number 25 in my reply. Page number 25 next of this. Translation since language is translated in page number 31. Page number 31.
No, Mr. Rama, since the petitioner is not present, saying what?
Challenging that there was KEVA was not clearly done.
Okay.
That was the challenge. So KEVA decision was in my favor. After hearing from the parties and after statement obtained from the base senior members, so they have declared that I am ordinarily belong to as per my DC. So they are given in my favor. So my younger brother then complained, now they are challenging that Keva was not there.
So what they are saying, that you are not Richie.
Yes, yes, my younger brother saying that they don't want to be become a Richie clan, they want to be GV clan. So as per my seniority, I am from Richie clan. So now it seems that the matter is to be referred back to the executive magistrate of ESC Jhansi to issue proper Keva as per another Civil Courts Act 2022. If any decision given by the village authority or by the inter-village customary court, so that will be challenged before the civil division or civil legal division as per declaration and peculiar judgment. So here this case is that this honorable court will decide the title of the plant, DC or GV. So my prayer is that
The Keba decided in your favor.
yes,
Then thereafter, straight away you have come or you have filed
there my younger brother filed this appeal
before this case.
stating that Keva was not fairly decided. So that's why they have
Not
challenged
fairly, or the Keba doesn't have any jurisdiction.
fairly not decided as per the agreement.
How the civil revision lies then?
Yes, that is. So,
Anyway, let him present. Let him be present. If that be so, then revision might not lie.
yes,
So let them be present if they want. So for 1 year, they did not file since last 1 year. What we'll do, we will give them last chance.
Yes.
But in the last occasion, you sought for adjournment.
I was in the
Okay. It appears that from the petitioner's side, they remain absent on many occasions.
Yes.
No, it was decided by, you said that it was decided by Keba.
So now
Now, if they are aggrieved, then they can, according to you, they can file before the civil judge.
yes, suppose they have appealed before the civil judge based on the decision being arrived but they have challenging for this honorable court and stay order has already been.
Okay. No one appears on behalf of the petitioner. It appears that the petitioner remain absent while Mr. Ramadana counsel for the respondent is present. Staff and para. As per the record, it appears that the petitioner remain absent for quite some time. And has not yet filed affidavit in reply since 2000.
14/9/2020.
Since 14/9/2023. Staff. Okay, be that as it may, the petitioner is given one last chance to file affidavit in reply. Staff. List this matter after 3 weeks. You are for respondent. Okay, what is your case? Yes. Inter-village. Inter-village village authority. Who is that village, inter-village village authority? What is the name of that authority? Who constituted this inter-village village authority? Hmm. There is affiliate jurisdiction, probably. This is original. They have exercised the original jurisdiction in the instant case. The complaint was initially lodged by whom? Against whom and where? Who is his informant? Complainant. Complaint was lodged before whom? Respondent number 6 lodged complaint. It cannot be. You are a petitioner. Okay, okay. You are for a petitioner. Respondent number? Okay, respondent 1, 2, 5 lodged complaint. Where do we find that? Page 34. This is Parwana only. No, where is the complaint? Yes, ma'am. This Parwana was issued to who are these Riram? Is the respondent, present respondent. Orium Riram. So complain, you don't have the complaint letter. You are this 1 to 5 in the Parwana. Okay. You are Dojum. 1 and 3 are blood brother. Okay, so it's among the brother. No, just a minute. So that means 1 and 3 also are son of Lidoriram. Now it's between the same party from the same village. Same village. So the disputed land is also in the same village. Where you have said, where have you said that there is this inter-village? It's not inter-village. It's a village council only. The village authority only. Yes. Okay, so four villages GBs are involved, and according to you are interpreting that this is the inter-village, not the one village authority, but inter-village. And according to you, if it is this cannot be the inter-village dispute. Okay, the other village doesn't have other village GBs doesn't have any authority to sit over and decide a matter. Now, just tell me whether this Mariam Ram GB the disputed land where it is located. Sago. So northern Asi, Chiku. So the complaint should have been before the head GB Sago. But then instead it was the complaint was lodged before head GVSC. GB 43. So this is inter-village traditional customary. So okay, from the initial stage, this inter-village initial complaint was entertained by this inter-village traditional customary. But then straight away it is placed before the inter-village, not before the same village. So you are agreed by this. So this decision decided in whose favor? In their favor. You are against the jurisdiction. So by this order, by this decision, they have decided what is the dispute about land in favor of the respondent. How many respondents are 4, 5, and you are alone? You are also 3. So your claim is that this is okay. Married, you are not. Okay. According to you, this inter-village traditional customary code doesn't have the power and jurisdiction to decide. the present case, as they are not the original they doesn't have the original jurisdiction. Okay, where do we find that? They will apply the amendment only, the amendment one later on. Civil Code Act amendment. Customary code. Yeah. Hmm? 7. Yes. Hmm. Yes. 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 Right. Yes. Yes. Hmm. Yes. Yes. According to this, the inter-village authority is the appellate authority from the village authority. Yes. Yes. From the village authority also, and from the inter-village authority also, if the person is agreed, the appeal lies before the civil court. Yes. Now, where do we find that it doesn't have the original jurisdiction? It's appellate. It cannot decide because supposing the dispute involves with two villages, then this will become original jurisdiction then. when the village authority itself declared that it's an inter-village authority, then it indicates that as per this act, it is a appellate authority. Hmm. Yeah, that is there. Either whether it is a decision of the village authority or the decision of the inter-village authority, or village authority, then the appeal lies before the civil court only. So, but now here he has come before this court. This is civil revision. It's not appeal. Revision saying that the inter-village authority, if you declares yourself as inter-village authority, doesn't have the original jurisdiction. You have exceeded or exercised the jurisdiction which is not vested on you, vested on inter-village authority. According to him, inter-village authority doesn't have the original jurisdiction. It is only appellate authority. So that is why they have filed this revision petition, not appeal. Appeal will definitely lie before the civil judge. So that is why. Why don't you file revision before the civil judge? Or if you are agree, appeal, then of course, then appeal is a continuation of the suit. Then it may decide de novo also. Now that is what he is saying. Land Council for the respondent is saying that in that case we'll have to examine the content, the claim. Because he says that someone and under this, the person staying somewhere, so that has to be decided by inter-village. It's not like that. What was the village it was located? Sago. Located. No. The person who decided is Mississippi. See, the person is residing in Siku village. The place of the suit lane, the lane in dispute is located at Sago. Then you see only one village council cannot probably if it involves with more than one village. The village authority, the GBs of that particular village also will have to be involved, and the village where you are staying also. Is it so? Is it so? Corona has been issued to the card for 50 times, and they have no limit to the first place. So, this has been the status of so, what are we doing? If there are lots of now, his clear stand is that this village authority claiming themselves to be inter-village traditional customary doesn't have the original jurisdiction. You have to satisfy that how it has an original jurisdiction. If it doesn't have original jurisdiction, they definitely doesn't have the jurisdiction to decide, sit over and decide the matter as inter-village customary court. Because if the dispute is one particular village, then they can name themselves as a village authority, not inter-village. And inter-village as per the act We have seen intervillage is the appellate authority. Can't. It doesn't have the power. Then that means it exceeded the jurisdiction, not vested on it. Then in that case goes, the order goes. Anyway, can you satisfy the court that it doesn't have the original jurisdiction, or you can also satisfy that it has the original jurisdiction, because it's a question of original jurisdiction. If it has the original jurisdiction, then definitely this court has the power and jurisdiction to decide. And then it's a question because it involves with the fact, of course. Other cases also, because that is true. You need to come out with some citation also, earlier decided cases, if the inter-village traditional customary court has original jurisdiction to decide. No, this inter-village is equivalent to Bango. It's a Bango Kebang. Then that also will do. That also will have. No. As per the earlier, Bango Kebang has original jurisdiction. Okay. Then this is also, this is according to you, is this inter-village traditional customary court is a Bango, another name of Bango Kebang, isn't it? And as per the act also, appellate court. Then if you have the decision that it has also, Bango Kebang has also earlier decided the original, entertained the original. No, not entertained. Okay. Yes. Original also. Okay. Not necessarily it has come to the appellate. That village. More than one, involved with more than one.
In that case, only when something is a particular village. In that case, there is
supposing if it goes, supposing if this order goes, this impugn order goes, then it has to go back to village. So the GB who has entertained this complaint has to endorse it to the same village. What was the village name? Sisiku Village Authority. He has to send it to settle it as per the act over and again. Any? Straight away. Now he is the informant again. He is the complainant again. If he doesn't go, if the party agree in that line, we can dispose of also. Because you say that you to that extent you concede that it is the appellate authority, and in that case, if you agree with that, unless of course otherwise, then we can dispose of with the direction that it doesn't have the jurisdiction power and jurisdiction to sit over and decide the matter, and then set aside and pass. Right? You want some more time? Okay. Then when do you want, how much time it will take? Otherwise, in any case, it has to go probably. December 10. So. Just a minute. What it says? Para? Para? Just a minute. No, the Bongo level cannot not. Doesn't say about a jurisdiction. It was a dispute of the in the same village. Where do we find in this decision? So. Okay. Okay. And in that case, okay, we'll come with the here if there's any decision. Otherwise, primary facing it doesn't have, huh? If you think that some clarification is necessary. Okay. On the prayer made by both the Land Council for the parties. List this matter again on 10, 12. Okay, 10, 12. There is interim. The interim or the class alias will continue till the next day. Okay.
We're supposed to pass, your lordship. We have already. Yes, your lordship. We have concluded our argument, your lordship.
This was regarding?
Your lordship, non-compliance of the fundamental procedure which is prescribed under in the Arunachal Excise Duty Act. Arunachal Excise Act, your lordship.
Okay.
Here, your lordship, the FIR was registered which was supposed to be carried out by the excise inspector itself. But instead of uh, uh, carry carry with power, the excise officer has lodged an FIR.
Okay, okay, that case.
Yes, your lordship.
Yes, yes, but then on that day,
Yes.
we forgot that to see, I thought of looking at it again. With a view to passing over. And
Yes.
this was you refer the para 6 of
Your lordship, yes, Bhajan Lal case, para 102(6), point number 6.
102.
Yes, Bhajan Lal matter. Paragraph 102 guidelines had been laid down, and in guidelines 6 number guidelines, your lordship. Number 6.
Okay.
Where there is a specific provision or remedy to deal with the certain matter, then in such case, it can be exercised inherent power under 482 for quash this act.
Where is the impugn order? Impugn order or impugn complaint?
Impugn FIR, yes, lordship. Annexure 1, page number 11 to 14.
Okay. So this FIR actually should have been entered by himself.
Yes, he should have investigated the matter by himself instead of lodging an FIR, because
Okay.
under Arunachal Pradesh Excise Act, your lordship, the power, duty, everything has been prescribed there in the act itself.
Okay. So kindly help, because
Yes.
last time,
Yes.
I have just forgotten. Let us refresh and just
Yes.
take the fact now. Okay.
Yes.
Heard Mr.
G. Talal.
from Learning Council for the petition. So I have also heard Mr. Learning additional people for the state of.
And your lordship, the informant was also present, and he has also considered that he
Yes.
has
Okay, yes.
jumped the procedure.
And also,
Gyatso. T.
Mr.
Gyatso.
T. Gyatso, yes. Appearing on behalf of the respondent number 2. Okay. Para. This is an under section 4, basically of the Code of Criminal Procedure 1973. For Wasim of Itanagar Police Station FIR number 44, 2024, under section 34, within bracket 1, AB Excise Act 1993. And the corresponding Itanagar Police Station case number 44. Okay, police station case number 44, 2024, under section 34, 1, 2, 3, Excise Act 1993. provision.
7. Yes, Your Lordship. Seven. The Arunachal Pradesh Excise Act, Your Lordship. Firstly, Your Lordship, directly come to the provision 75. The cognizance of an offense. No magistrate shall take cognizance of an offense referred to in section 34, section 37, section 43, or section 44, except on his knowledge or suspicion, or on the complaint or report of an excise officer or an officer empowered in this behalf by the state government. And B is in section 45, section 49, clause D or clause E, or section 50, except on complaint or report of the collector authorized by the collector in this behalf. So it should be a complaint, Your Lordship, directly. And under CRPC, Your Lordship, the complaint is defined. What will be the complaint, Your Lordship, in section 2 of the CRPC? And the report which is referred here is the report to be filed by the officer itself, excise officer, after conducting investigation. That we find in section 66, power and duty of collector and certain excise officer investigating offences. Excise Act, Your Lordship. In this, yes, 66. 65 and 66. Your Lordship, will start from 65. Says a collector may, without the order of the magistrate, investigate any offence punishable under this act, which a court having jurisdiction over the local area within the limit of the collector jurisdiction would have power to inquire into or trial under the provision of the chapter 15 of CRPC 1973 relating to the place of inquiry or trial. Any other excise officer especially empowered in this behalf by the state government in respect of all or any specified offences punishable under this act may, without the order of the magistrate, investigate any such offence which a court having jurisdiction over the local area to which such officer is appointed would have power to inquire into or try under the aforesaid provision. Now 66. Any collector or any excise officer empowered under section 65, subsection 2 may, after in writing his reason for suspecting the commission of an offence which he empowered to investigate, exercise any of the power conferred upon police officer making an investigation or upon officer in charge of a police station by section 160 to 171 of the Code of Criminal Procedure 1973, and B, as regard offences punishable under section 34, section 37 and 43 or section 44 of this act, any of the power conferred upon police officer in respect of cognizable offences by clause A of subsection 1 of section 90 and by section 44 of the said code, and the said portion of the said code shall apply accordingly, subjected to any restriction or modification prescribed. 2. Subject to any restriction prescribed by the state government, a collector or a excise officer empowered under section 65 of the subsection 2 may, without reference to a magistrate and for the reason to be recorded by him in writing, stop further in proceeding against any person. They can stop also, Your Lordship, or supposed to be concerned in any offence which he or any excise officer subordinate to him has investigated. 3. For this purpose of section 156 of the Code of Criminal Procedure 1973, the area to which an excise officer empowered under section 65 subsection 2 is appointed shall be deemed to be a police station, and such officer shall be deemed to be the officer in charge of the station. For as soon as investigation by a collector or by an excise officer empowered under section 65 subsection 2 has been completed, if it appears that there is sufficient evidence to the investigation officer, unless he proceed under subsection 2 of this section or under section 56 of this act, shall submit a report which shall, for the purpose of section 190, that is for cognizance of the Code of Criminal Procedure 1973 be deemed to be a police report. 10. A magistrate having jurisdiction to inquire into try the case and empowered to take cognizance of the offense on the report. This is the procedure, you will say actually. 66. And under 65, the collector and the excise officer are empowered. So this is the procedure actually, which is not at all complied with. He himself has lodged an FIR. And the provision of the CRPC will apply in this case. Why? Because your lordship, this case is pending prior to the implementation of new code. This
Prior to implementation.
of this BNSS.
Okay.
So this CRPC's provision can be reflected in the order because it was pending prior to the implementation of new.
Yeah, if the petition. Okay. The internal application, FIR number 23 of 2023 by the registrar on consent by the respondent number 2. Who is the assistant inspector? Tax and excise within the narco. John from Office of Commissioner of Tax and Excise, Canada. Wherein it was believed that a team of police and flying squad team conducted checking of wine shop at Chandra area on 2024. During this exercise, it was discovered that one wine shop named TV Family Wine Shop, whose located there is running from Percy Pario complex, Chandra Nagar. In 56,954 details of the found in the search where here comes again the start and investigated into stuff. Being agreed by the registration of the FIR and the investigation being taken by the respondent number 2, the petitioner preferred this petition, criminal petition, amongst other on the following grounds. the this is in order.
No, Your Lordship. After filing of the charge sheet, the matter was endorsed by the CGM to the JMFC, and JMFC has also reflected that the cognizance has been wrongly taken. But the matter has been stayed because there was a stay order from this honorable court. So that is the latest, that is the last order perhaps passed by the London trial court.
On the stay order passed by this court after.
Yes. Now we have to be very cautious because of that incident CAV matter, Your Lordship. We have to properly see the trial court record also. That morning the matter I have mentioned. Otherwise, Your Lordship, in fact, the hearing before the court was amounting to abuse of process without knowing the effect of the passing matter, the CAV matter.
Yeah, that was there. I have already dictated it.
Yes, yes, yes. Yes.
Oh,
That's an issue, Your Lordship.
2 hours, 2.5 hours. It is submitted as the investigation of the offense under section 34 of the AP Excise Act is to be investigated by the collector or an excise officer. It is further submitted that the powers to investigate an offense in such case flows from section 66 of the AP Excise Act 1993. And under after stop and under section 75 of the same act, it is provided that no magistrate shall take cognizance of an offence referred to under section section 34. Section 37, section 43 or section 44, except on his own knowledge or suspicion or on the complaint or report of an excise officer or an officer empowered in this behalf by the state government. Or state government. Stop. After that, there is 56 close form. It starts from 65(1). 66(1).
Procedure part.
Hmm.
Procedure part, yes, Your Lordship. 66(1). Power and duty of collector and certain excise officer investigating offences. 65 provides power of the collector and certain excise officer, and 66 is the power and duty, and that is procedure, Your Lordship. How to carry out.
Attorney Counsel for the petition of Father Sam is that the procedure for investigation, the procedure for the investigation of such case is provided under 66 of the CJ. The subsection, section 1, 2 will have to.
Section 1, 2, Your Lordship.
1, 2, 3, 4.
Yes, Your Lordship.
Okay.
1, 2, 65, 1, 2, 3, 4.
Section 66.
66, section 65 is 1, 2, and 66 is 1, 2, 3, 4.
65 is necessary.
65 is not necessary. Power is
65, 66.
Yes.
Is reproduced here in the.
Yes, sir. 4.
66, 1, 1A, 2, 3, and 4. Okay. It is further submitted that the procedure established by the statute which Arunachal Pradesh Excise Act 1993 supersedes the procedure of investigation provided under the Code of Criminal Procedure 1973. So thus, no FIR can be registered for contravention of Section 34 of the Arunachal Pradesh Excise Act 1993. In view of the above, the Land Council for the above submission from the Land Council for the petition further submits that the above impugn Itanagar Police Station FIR number 44 2024 under section 34(1) AP Excise Act 1993, and it was still under ongoing investigation.
No, Your Lordship, it's charge sheeted, and Your Lordship, the matter is already committed to JMFC.
Okay. And the investigation and subsequently charge sheeted before the JMFC.
Yes, it's pending before the JMFC.
JMFC.
Yes, UPI.
Okay. Is bear in law and same is liable to be set aside and passed. Mr. Ete, Land Addition PP. While considering the submission made by the Land Council for the petition, fairly submitted that as per the fairly submitted and not fairly submitted as per the provision under 66.
Yes, Your Lordship. 66.
Of the Act of the AP Excise Act 1993. The excise officer, no, by any collector or any excise officer empowered under section 55 of clause 2 is all this section only. You have voted the section only. Giving this.
Yes, Your Lordship.
After recording in writing his reason for suspecting the commission of the offense. He is empowered to investigate. Any of the power conferred upon police officer making an investigation. However, in the instant case, the Assistant Inspector Tax and Excise Narcotic has lodged the above FIR before the officer in charge police station. Who then had investigated the case and also submitted charge sheet before the Land Court of Judicial Magistrate First Class. This 75 says no magistrate shall take cognizance of the case, refer to the judicial magistrate.
Jurisdiction to try the offence. Your Lordship, perhaps it's refer to judicial magistrate third class, I think, not less than second class, Your Lordship.
Okay.
A magistrate's power is
First
not
up
less.
is that in such cases, no magistrate shall take a case is provided under section 75 of the Act. No magistrate shall take cognizance of an offence referred to in section 34, except on his own knowledge or suspicion, or on the complaint or report of an excise officer or an officer empowered to his behalf, empowered in his behalf by the state government.
Magistrate is referred in section 74, Your Lordship, whose power are not less than those of a magistrate of second class.
So, but the magistrate doesn't have any power here.
Yes, Your Lordship. Yes, Your Lordship.
The authority himself could have taken up.
Yes, yes, absolutely.
And since the and as provided under the provision of the AP Excise Act 1993. The Assistant Inspector Tax and Excise Narcotic himself could have taken up matter for investigation.
Yes, Your Lordship.
Okay.
Investigate the matter.
And investigate the matter. And he could pass order also.
Yes, Your Lordship.
And pass necessary order. As required.
Your Lordship, if he is so empowered under this act,
He is empowered only.
Your Lordship, that perhaps he is empowered, but Your Lordship, there is no any specific order,
Okay,
anything
okay,
here.
if he is empowered, huh?
Yes,
Then
under
what
this
do we say about this empowered, whether he is empowered or not? Under the,
Yes, Your Lordship.
he is empowered.
Your Lordship, whether he was empowered or not, that part is, so far as the court is concerned, we don't have, because he is the assistant excise officer. But so far as the act is concerned, it clearly says any other excise officer is especially empowered. So that is why if he is especially empowered on this behalf under this act, then he ought to have investigate the matter by himself.
Okay, if the assistant, yes, assistant inspector tax and excise, if empowered,
Yes, yes.
ought to have exercised his power and investigated the case by himself.
Yes,
and
absolutely.
pass necessary order.
Yes. This, to some extent, it's like Your Lordship, NDPS also, gazetted officers are there, but all are not empowered.
Okay.
It's specifically empowered in this behalf. Yes, that is why. So that it shouldn't be misunderstood by in any other cases that assistant inspector
Then
is.
in the instant case,
Yes.
so since there is no specific order
Yes.
empowering him.
Yes, exactly.
to investigate, what do we say about?
So, yeah, if he is so if he is empowered, then he ought to have.
But here in this case, we do not know whether he is.
Yes, if he is not empowered, there is no any question of he is not. If he is not empowered, then he don't have any authority to do
He
anything.
has a power, he can investigate.
Yes, exactly.
Okay. The non-council for the party. Upon hearing the party and on perusal of the records, provision under the act, provided under the Governance of the AP Excise Act. It appears that the procedure contemplated under the provision of AP Excise Act has not been followed in the instant case. The assistant inspector tax and excise narcotics, as per the act, if he is empowered, ought to have carried an investigation by himself, carried out the investigation by himself. In view of the above. However, in the instant case, the respondent to assistant inspector tax and excise has instead lodged an FIR before the officer in charge police station, who then has registered a case, investigated into, and also filed charge and subsequently filed, and on completion of investigation has submitted and laid the case with the charge sheet before the judicial magistrate first class. The above procedure followed is not in terms of the provision provided under the AP Excise Act 1990. Accordingly, in view of the above, and for the region as stated above, the Itanable police station FIR number 44. Then it has to go.
Yes, Your Lordship.
2024. Under section 34(1), AP Excise Act 1992, and the corresponding Itanagar police station case number 44/2024. Under section 34(1), AP Excise Act 1992. Charge sheeted, do we have?
Charge sheeted and GR number is also there, Your Lordship. Your Lordship, fine in the order itself, reflected. Maybe on the first page.
This in the order.
First page, Your Lordship. The cover only, I think, Your Lordship. Cover of the file cover, yes.
Corresponding GR case number 160/11. In connection with the PS case number 44/24 under section 34 within bracket A, AP Excise Act. So GR case, mentioning GR case is enough, I think.
Yes, Your Lordship. FIR any subsequent criminal proceeding or the GR case.
And the subsequent criminal proceeding in the above GR case. No?
Yes.
No. This is GR case different or what?
Hello, it is in the subject, I believe.
So this is PS case number 7 under section GR case number 2/2024. But then here again it says that the aforementioned GR case number 160.
One more, check here. One more copy is here. 220. The GR is 220, Your Lordship. Here also it's reflected GR number.
GR number
220, Your Lordship.
220 only.
Your Lordship.
GR. Then why they had mentioned this 150?
Did file also 220.
Okay, GR case would be 2024. Huh?
220.
Against the petitioner. What is his name?
Srimati Mingam Karcho.
Mingam
Karcho.
Karcho. He here was set aside.
Yes.
And plus. With the above. This criminal petition is allowed in disposal.
Yes. Record may be sent back, Your Lordship. It is the original record, I think, from GMFC.
Send back the record.
Yes.
Immediately.
Yes. Much deeply obliged. Service is perhaps completed, Your Lord. Let this matter be list for. Your Lordship, let this matter be list for hearing. If the respondent doesn't appear, then we'll pray for it.
One more paragraph is to be added. Yes. Item?
Item 16, Your Lordship. Yes, it's a criminal appeal against special court order POXO matter, Your Lordship.
Okay.
The notice was issued to the victim and accordingly the service has been returned, served, service completed. So Your Lordship, now this matter is to be fixed for hearing. And if they do not appear on the next date, we'll pray for appointment of the legal aid counsel, Your Lordship, for the victim.
You are for?
I might just.
For appellant.
Okay. Holding the land and my place clearly is present. Also with the land is in PP. PP is also present. Victim not represented.
No, Your Lordship, service completed, Your Lordship. Not represented
So
today.
I think
Legally.
service completed, no one appears, probably
From,
we need to direct for appointment.
yes, Your Lordship. From the panel of legal aid service.
Service in respect of the respondent number 2, victim, is the office note dated 8/11/2024 reflect that the service in respect of the respondent number 2, victim, is complete. However, no one appears on behalf of the said respondent number 2. In view of the above, from the register from Secretary, High Court Legal Services Committee is directed to appoint one legal aid counsel from the panel of legal aid counsel of the High Court to represent the respondent number 2 victim. List this matter. You have received the copy?
Yes.
Okay.
After 4 weeks, Your Lordship.
Okay. List this matter after 4 weeks.
4 weeks, yes, Your Lordship.
The paper book is ready and received by the my class and the it is on PP.
Yes, Your Lordship, we have received.
List this matter after 4 weeks. Okay.
Yes.
For hearing.
Yes. Obliged.
Yes. Your Honor, on last occasion, CD was called.
Your Lordship, CD was called for, but unfortunately, we have not received the case diary yet, Your Lordship. It's a joint petition, otherwise, Your Lordship.
Yes.
Yes.
Yes. Moreover, Your Honor, there is one more matter, criminal
What is
petition.
the offense involved?
This is offense, section 115, 74, 351 close, subsection 3, 3242, 296.
Where did the counsel? Next.
Yes.
This is against unknown young couple.
But Your Honor, the couple was identified later. Huh?
Later on.
Yes, and they have settled the matter also.
Only
One
one
thing
section is non-valuable. Only one section is non-compoundable.
Which one?
Matter is under investigation, so.
Is it still under investigation?
Yes, it is.
It is quite.
Yes, leave for case diary, Your Lordship.
And
Scan
moreover,
copy.
Yes, Your Lordship.
Okay.
uh,
You are Mr.
Tempahi, Pahi,
Learned Council for the petition. Mr. Learned Edition PP. Submits that. The 10 copy of the LCL is both as notes of this.
No, case diary, Your Lordship.
Oh, sir, case diary?
Yes.
10 copy of the case diary is yet to receive. And place for some more time. The prayer is allowed. List this matter after?
1 week.
After a week, on which date?
My lord, one more prayer is that criminal petition number 153 may list together with this two, I think.
Okay. For some time, praise for some more time. Stop. Prayer allowed. List this matter after a week.
After a week.
Okay.
Item number 21 is.
Item, which one? 21?
Yes, 21 is also interconnected.
Okay, list this matter along with criminal petition number 152. 152. After a week.
And 153 also, which is not.
153 also?
Yes.
They're all arising out
Out
of
of what same?
Okay.
FIR and
153. 153, where it is not listed today.
Yes.
It's not listed today.
152 and 153 after a week.
Yes.
On which date? The recent PP shall produce an updated scanned copy of
Yes, sir.
case file. Okay.
Much obliged.
Obliged.
Yes.
After.
Yes.
Yes, my lord, your honor. My lord, I want to submit.
This is bail.
Yes,
Regular bail, Your Lordship.
my lord.
Yes.
Fact of the case is that
What is the allegation? Let us see the fact for you.
FIR is page number 14, 15, 16, and 17.
Which is, what is this? FIR is
It's a murder case, Your Lordship.
not in Arunachal.
Yes, Your Lordship. It's a zero, actually zero FIR was
Zero
lost.
FIR, okay.
Yes. And incident is happened in Daporijo, Your Lordship. It's not a zero, it's a zero FIR. It's written is ZIRO. It should be ZERO.
ZE.
Yes, yes. It's a zero FIR.
Zero.
Yes. And the parents is from Assam.
So. Dhemaji. Okay, it was, the FIR was lost.
At Likabali.
Dhemaji.
Zero FIR, yes. And later on, the same was registered at Daporijo, Your Lordship.
In charge, recovery for Dhemaji, Assam. It is in Assam only, Dhemaji.
Yes, Your Lordship. Zero FIR. Next, one series. You.
Procedural.
The FIR, the section registered is 143 and section 35. And
140.
140 is the kidnapping, subsection is kidnapping. However, Your Lordship will find in page number 20, annexure 3, here the JMFC has reflected more sections. Meaning thereby later on the investigation authority has perhaps added more sections because earlier the offense or allegation was regarding kidnapping and abduction. But later on, Your Lordship, perhaps he is found to be murdered, Your Lordship.
Subsequently.
Yes, Your Lordship. It's reflected in JMFC's order, Your Lordship. Otherwise, for section 140 subsection 3, the punishment is only extend up to 7 years. For abduction. On 6/11, the latest bail rejection order of the district and session judges, Annexure 5, page 26, 6/11/2024.
6/11.
Yes.
What about this other? There are other order also. 6/11. How many accused are there?
Here is 8 accused, Your Honor. 8 accused, Malay.
You are for one only.
Yes, I'm for.
Okay, 6/11 is the latest rejection order.
Yes.
Yeah,
You know, in this latest reject order, here is not mention only 140 3 oblique is
the incident took place at Daporijo.
Yes.
Okay, this is allow. Okay, okay. 6/11. Day before yesterday only it was rejected.
Yes, it's the Daporijo PS case number 6024.
Daporijo PS case number
6024, Your Lord.
under section 140.
And here the accused is Yachak Rai.
Yes.
Yes.
Yachak, same.
Yes, Your Lordship.
That was rejected.
Bail was rejected on 6/11 itself, Your Lordship. Only 5 days back. Your Lord.
My Lord, this bill was rejected by the London Session Additional Session Court, Basar. I will file a Basar before.
Additional?
Additional District Session Judge Basar.
No, additional.
Where?
It's a district and session judge.
Additional district judge in Basar.
This one.
District judge. Hello.
Basar. Case was hard in Basar, allow, but I have filed before the Basar, Your Honor. My Lord.
There is no court in Basar.
But case bail, any file may be go through the Basar.
Perhaps, Your Lordship, there is no session judge there at the station in Basar. So, Alo Bas, perhaps the Alo district judge, yes, has been given charge.
Because
So,
the Basar also comes under Alo.
yes,
Sessions Division.
yes. It's because it's written also Basar BA application.
Yes. But exactly.
But the matter is from Dapo only. That is the fact. From Dapo Rijo PS case number. It's a 0 FIR initially registered here at Likabali and it was registered there at Dapo Rijo subsequently.
Yes. My Lord, my prayer is that accused person see he's having a breastfeeding baby, Your Honor. Moreover, doctor has been already referred to the claims, Your Honor. I have annex. I have annexed my annexure 7, page number 28, 29, 30.
The Lana District Session Court, after considering your medical examination report also, then rejected the bail.
Yes.
Rejected your bail.
No, my Lord. Before the rejection, after out of the case, this medical report has been come. I have received.
Your Lordship will kindly come to Annexure 4, 23. One, your lordship, her medical condition was considered. And on 23rd, regarding her lactating child has also been considered. The two aspects has already been considered.
Both the ground, all the ground we have taken. has
Uh,
rejected.
Moreover, one thing is that, my lord, accused was arrested on 2nd September 2024, and now she is in custody of 69 days, my
Again,
lord.
It will be 90 days only. Because it's up to life.
My lord, this section is punishable by under 7 years.
Record also not necessary to poll board.
Yes, exactly.
What do we do? Still you want see the record?
Yes, yeah.
Because your bail repeatedly it was rejected on both the ground you have. What is the new ground you have taken? Because in both the ground, your bail was rejected.
My last prayer is that, my lord, now she is 69 days. So
69 days is in the murder case. 69 days. It is 90 days.
Yes.
And then failure to submit charges
My-
within this 90 days, then only you will be entitled to.
my lord, my submission is that whether the accused person is involved in the murder or not.
That is
As I
why she
pray,
is in jail. Prima facie she was found involved. That is why she is in jail now.
no, she is not involved in the
That will
murder.
be in the trial. That will be in the trial. But for the time being, prima facie she is
My-
involved. That is why she is in jail now.
My prayer is that, my lord, CD may be called.
CD,
If-
you see,
if-
after perusal of the CD only on
Yeah,
merit also and on medical ground also, your bail application was repeatedly rejected.
If CD is said that the C is involved in murder, then this your lordship may be reject the bail. If CD say that yes, accused person C is involved in the murder, then your lordship may be reject the bail.
She was the person who called the victim, your lordship. It's clearly reflected there in the order. All the orders are there. Your lordship, I will find in page number 20. This on merit. The prosecution in brief in that on 23rd and 24, the accused person along with other co-accused have abducted the victim, namely Sanjay Nath, and handed over to the accused person, namely Tabu Doni, and the victim was later on murdered by the accused persons. And there are 9 accused persons are involved in committing abduction and murder of the victim. Hence, the case is registered under section so and so and so.
See, on all the ground, merit.
Merit
on all
also
the ground,
medical.
your bail was rejected only recently, very recently.
And your lordship, their medical ground was also considered. Your lordship will find in page number 28, the order was passed by on the direction of the court, the board was constituted, your lordship. And the report of the medical board examination is there in Annexure 6, page 30, your lordship. And its report is of 26/10/24. That means bail is of 6/11/24. That means court has considered this medical ground board report also.
26/10.
Yes, your lordship. Your lordship find the signatures of the doctor is on 20/10/2024 or 26/10/2024. And the latest bail order rejection is 6/11/24.
Yes, sir. On medical ground.
Gastric
So you
ulcer.
see, subsequent filing of bail application will not entitle you for release. This is, you see, abuse of the process that amounts to, because what is the value of filing subsequent bail application one after another? That will disturb the idea
Yes.
of the case. Rather, calling all the records time and again. Your bail application has been repeatedly rejected on all grounds taken by you. And then you have not taken any new ground for filing bail application before this court. No need to call case diary also, it appears.
Yes, at this stage, your lordship, now it's the investigation stage. It's as my brother has already said, it's 60 something days is there. Your lordship is aware it's if murder is there, sometimes the 90 days is also not sufficient. But if within 90 days the charge sheet is not filed, he will be entitled for the indefeasible right. But prior to that, your lordship, there is a prima facie case. Even if they subsequently file, there will be same outcome, your lordship, because all the materials are remain intact.
Mister, you are Mister?
Tinyogan.
Atlantic Council for the petitioner. Or what, you think that justice?
Yes, Your Lordship. For ends of justice may record this CD, scan copy of CD may be called for.
Where? This is an application filed under section 483 of the BNSS Act 2023, praying for grant of bail to the accused. What is her name?
Yachak Rai.
Yachak Rai, Srimati Yachak Rai, who has been arrested in connection with the Procedural case number 60/2024, 60/24 under section 140 within bracket 3.
1031.
Where do you find?
Your Lordship, in some order, Your Lordship, sections are not mentioned, but in JMFC order,
The latest order.
latest order also, Your Lordship, the additional section were not mentioned.
Not mentioned.
Yes, Your Lordship.
So additional section, where do we find?
Your Lordship will find in the page number 20, actually. This is the first initial order.
Hmm.
Your Lordship will find in page number 20, it is passed by the JMFC, Your Lordship. Here, Your Lordship, hence the case is registered under section 143, 1031.
Okay.
Yes.
Is page number, and so under section 140 within bracket 3, 103 within bracket 1, 238, 3 within bracket 5 of BNS.
Yes, Your Lordship.
For the scan copy of the case diary. So, thanks, Mr. Creative. Non-addition PPF, an accepted notice. Sorry, Mr. Accepted notice on behalf of the state, not his. State respondent. List this matter.
On 21st.
21st?
Yes.
Okay.
Obliged.
Obliged.